Mr. President, we will shortly consider making right the things that are wrong with the so-called Protect America Act, a second-rate piece of legislation passed in a stampede in August at the behest of the Bush administration. It is worth, for a moment, considering why making this right is so important. President Bush pressed this legislation not only to establish how our government can spy on foreign agents, but how his administration can spy on Americans. Make no mistake, the legislation we passed in August is significantly about spying on Americans, a business this administration should not be allowed to get into except under the closest supervision. Now, we have a plain and tested device for keeping tabs on Americans. It is our Constitution. Our Constitution has, as its most elemental provision, the separation of governmental powers into three separate branches. When the government feels it is necessary to spy on its own citizens, each branch has a role. The executive branch executes the laws and conducts surveillance. The legislative branch sets the boundaries that protect Americans from improper government surveillance. The judicial branch oversees whether the government has followed the Constitution and the laws that protect U.S. citizens from violations of their privacy and their civil rights. It sounds basic, but even an elementary understanding of this balance of powers eludes the Bush administration. So now we have to repair this flawed and shoddy Protect America Act. Why are we in Congress so concerned about this? Why is it so vital that we energetically assert the role of Congress and of the courts when the Bush administration seeks to determine the rules under which it will spy on Americans? Because look what the Bush administration does behind our backs when they think no one is looking. For years under the Bush administration, the Office of Legal Counsel within the Department of Justice has issued highly classified, secret legal opinions related to surveillance. This is an administration that hates answering to an American court, that wants to grade its own exams, and OLC is the inside place the administration goes to get legal support for its spying program. Mr. President, as a member of the Senate Intelligence Committee, I was given access to those secret opinions and spent hours poring over them. Sitting in that secure room as a lawyer, as a former U.S. attorney, legal counsel to Rhode Island's governor and state attorney general, I was increasingly dismayed and amazed as I read on. To give you an example of what I read, I have gotten 3 legal propositions from these secret OLC opinions declassified. Here they are, as accurately as my note-taking could reproduce them from the classified documents. Listen for yourself. I will read all 3 and then discuss each one. 1, an executive order cannot limit a president. There is no constitutional requirement for a president to issue a new executive order whenever he wishes to depart from the terms of a previous executive order. Rather than violate an executive order, the president has instead modified or waived it. Number 2, the president, exercising his constitutional authority under Article 2, can determine whether an action is a lawful exercise of the president's authority under Article 2. And 3, the Department of Justice is bound by the president's legal determinations.